izethulo ke isho ummeli wenu nomshushisi ke futhi mayelana ke na ukuthina ke bafuna icala leli lithwetshulwe leli ke ushilo lapha ummeli wenu uthi akanankinga ukuthi icala lingathwetshulwa kepha ke ikhona ke imininingwane efanele ke ingavezela yona ke imito bengayithwebuli mayelana ukuthi mhlawumbe ke obani mhlawumbe ke ingane zenu enizondlayo lapha ke izongena kakhulu egxila kakhulu ke empilweni yenu ayona ke ingafanele lapha ke ithwetshulwe ke lonto lo ke abaphikisana thina ke ingaqhubeka imedia noma mhlawumbe abathwebuli bezindaba lapha ukuthi ke beqhubeke ukuthi bethwebule icala na umshushisi akaphikisana futhi nalesi sicelo. Izoqhutshwa kwa ukuthi icala lithweshulwe kepha ke lezo ngcenye lekwe abathena abacela ke ingathwetshulwa ke iyona ke engeke izenzeke. Ningahlala phansi lapho ke lalisiseke uzoshula kanjalo. Dani khona phansi.
As the court pleases. As my learned colleague representing the state has correctly pointed out that the request was initially served on the state, which request was declined by the state. Pursuant thereto, an instruction was given that a formal request be moved in court. In that regard, Your Worship, while reading the same into the record, may I ask leave to hand up the original of the request. As this is with the leave of the court, may I read the same onto the record. In the Magistrate Court for the District of Mkondo, held at Mkondo, case number A11 of 2025, in the matter between Sifiso Dlala, the first applicant, Mawilis Snentlahla Mdlolo, the second applicant, Sandis Ndlela, the third applicant, and the state as the respondent. The request for redacted particulars. Paragraph 1. Section 60, subsection 14 of the Criminal Procedure Act provides as follows. Notwithstanding anything to the contrary contained in any other law, no accused shall, for the purposes of bail proceedings, have access to any police information, record or document relating to the offense in question, which is contained in or forms part of a police docket, including any information, record or document which is held by the police official charged with the investigation in question, unless the prosecutor otherwise directs, provided that this subsection shall not be construed as denying an accused access to any information, record or document to which he or she may be entitled for the purpose of his or her trial. Paragraph 2, section 11 states that in Schedule 6, the accused shall order that the accused be detained in custody until he or she is dealt with in accordance with the law, unless the accused, having been given a reasonable opportunity to do so, adduces evidence which satisfies the court that exceptional circumstances exist which in the interest of justice permit his or her release. Paragraph 3, in the case of State versus Mauk, 1999, Volume 2, SACR 479W, the former WLD division, the court held the accused can also have access to the police dockets to discharge the honors for exceptional circumstances in terms of Section 60(11)A, despite Section 60, subsection 14 of the Criminal Procedure Act 51 of 1977, which says otherwise. Paragraph 4, in the case of State versus Green and another, 2006, Volume 1, SACR 603 SCA, it was held that the state can be ordered to grant the defense access to the docket for relevant items. 5, in the case of State versus Lamin, State versus Dlala and others, State versus Jubair, State versus Kitekat, 1999, Volume 2, CCR 51, CC. The Constitutional Court held that notwithstanding Section 60, subsection 14 of the Criminal Procedure Act 51 of 1977, the prosecutor may be ordered by court and under subsection 11 to lift the veil in order to afford the arrestee the reasonable opportunity prescribed there. Subsection 14 cannot be read as sanctioning a flat refusal on the part of the prosecution to divulge information relating to pending charges. Paragraph 6, Section 35 2D of the Constitution of the Republic of South Africa states the following: everyone who is detained, every sentenced prisoner has the right to challenge lawfulness of the detention in person before a court, and if the detention is unlawful, to be released. Paragraph 7, it is common cause that the honors rest upon the applicants in terms of bail applications which fall within the scope of Schedule 6. 7.1, in order to prepare adequately and attempt to discharge that honors, we humbly request particulars redacted at this point in time in the form of the following: 1. Witness statements. 2. Statements by arresting officer. 3. Statement of any evidence which links the applicants to the alleged commission of the offense, that is, any confession statements. 4. Any other relevant statements or evidence. 7.2. In essence, a copy of the entire police docket with personal particulars which are redacted. Paragraph 8. Considering the above mentioned legislation and case law, it is respectfully submitted that it will be in the interest of justice to have the particulars furnished to the defense, dated and signed at 11 on this 28th day of January 2025. That is the applicant's case.
Lesi-ke statement esifunda laphana-ke ummelweni laphana-ke ekumayelana laphana-ke nesicelo-ke abasenzayo la enkantolo laphana ukuthi-ke benikezwe laphana-ke imininingwane emkhona laphana-ke kwi-docket laphana-ke lokhu bakwenza laphana-ke ngomthetho laphana-ke kwezamacala laphana kusigaba 60 laphana isigajana 4 lona okuvezayo laphana ukuthi ke ummangali laphana-ke kuyaveza ukuthi umuntu laphana ongummangali laphana-ke ngenhloso laphana-ke yokuqhuba laphana isicelo sakhe sebheyili laphana-ke fanele laphana-ke enikezwe laphana-ke imininingwane laphana-ke equkethwe laphana-ke emaphoyiseni laphana-ke ehlobene laphana necaleli-ke elenzekile laphana-ke noma-ke alenzekayo laphana-ke akufanele laphana enikezwe laphana-ke leyo mniningwane ngaphandle uma ukuthi umshushisi-ke khona laphana-ke akuvezayo laphana-ke uyaveza futhi laphana-ke laphana ngokuthina ngawo umthetho futhi okusigaba 6 laphana isigajana 11 laphana kuyasho uma icala laphana-ke lischedule 6 laphana-ke kuyasho umthetho laphana ukuthi kufanele laphana-ke ababangalelo laphana-ke begcinwe ngaphakathi laphana-ke ey'tokisini laphana-ke ukuze icala bo lize liphele laphana-ke ngaphandle uma ukuthi laphana bazonikezwa ithuba laphana ukuthi beveze ubufakazi laphana-ke ukuthi-ke akhona amaphuzu angajwayelekile laphana-ke anobulungiswa laphana ukuthi ngeke-ke ningakhishwa-ke laphana-ke ngayo laphana-ke ibheyili laphana-ke wenze umzekelo ngelinye icala elenzeka phambilini laphana-ke u-state versus Mawuk laphana-ke lenzeka phambilini laphana-ke esho laphana-ke ukuthi ummangalelo laphana-ke fanele laphana ebe nalo ilungelo ukuthi akazi laphana ukuthi idocket laphana liqukethe ini laphana ukuze laphana-ke ezolungiselela laphana yona-ke amaphuzu-ke amasha-ke laphana-ke angajwayelekile laphana-ke uwenze futhi umzekelo laphana ngelinye icala laphana-ke elenzeka futhi phambilini laphana-ke asho laphana ukuthi umbuso laphana-ke lapho unganikeza laphana-ke ummeli weni laphana-ke okuqukethwe laphana noma-ke idocket laphana-ke okubalulekile laphana ukuze laphana ezolungiselela lona-ke icala laphana-ke uwenze futhi omnye umzekelo ngelinye futhi icala elenzeka phambilini laphana ka-State versus Dlamini no-State Dladla laphana-ke lecalekile lakhulunywa laphana-ke enkantolo enkulu laphana-ke inkantolo yomthetho sisekelo laphana-ke lapho-ke ekwaveza khona laphana ukuthi lapho kwaveza khona laphana ukuthi umuntu meboshiwe laphana kufanele nikezwe laphana-ke lona-ke ithuba laphana-ke ukuthi azame laphana ukuthi azi ukuthi kunani laphana phakathi-ke kwi-docket laphana-ke nanokuthi lokho-ke akufanele laphana-ke kube kumcindazela laphana ukuthi emnqabele-ke lona-ke ukuthi kuqukethwe ini laphana kwi-docket laphana wenze futhi-ke omunye uwenze laphana-ke futhi wathatha laphana umzekelo laphana-ke wenzekile lapha kumthetho sisekelo laphana-ke okusigaba 35 usigajana-ke 2 laphana laphana kuyasho wonke umuntu laphana oboshiwe noma umuntu laphana osegwetshiwe laphana-ke engayifakela laphana-ke inselelo laphana-ke uma ukuthi uboshwa kwakhe laphana-ke akukho emthethweni-ke ukuze akhululwe Nanokuthi futhi laphana uyaveza laphana ukuthi bona-ke njengoba laphana-ke becela inkantolo laphana-ke ukuthi na-ke ibanikezele yona-ke imininingwane equkethwe ilona-ke idokethi laphana-ke imininingwane abayicelayo laphana-ke kuphela iy'tatimende zofakazi laphana-ke istatimende futhi-ke sephoyisa-ke elanibophayo nanokuthi futhi into abayicela laphana-ke ubufakazi lobu-ke okunibandakanya-ke naleli cala lapha-ke noma mhlawumbe nikhona lapha-ke iy'tatimende enazenzayo laphana ukuthi nilivume-ke leli cala ukuthi niyenzile laphana-ke nanokuthi bafuna futhi iy'tatimende-ke ezibalulekile laphana-ke ezinobufakazi ukuthi leli cala leli-ke nalenza laphana-ke uyasho laphana ukuthi na-ke amaphoyisa fanele laphana mhlawumbe benikezelele yona-ke amakhophi ayo lo mniningwane lo-ke ekhona laphana uyasho na-ke lokho-ke kubhaliwe kushicilelwe laphana kumthetho sisekelo nasemacaleni-ke angaphambilini ekenzeka phambilini laphana-ke asho laphana ukuthi na-ke kube nobulungiswa laphana-ke ukuthi kunikezelelwe yona-ke imininingwane noma benikezelele-ke yona-ke ummeli wenu-ke ngayo le mininingwane lena abayicelayo laphana le statement esike-ke nesayinile laphana-ke ummeli wenu khona-ke lena-ke emarisburg khona-ke eDurban. Niyaqiniseka ukusho ummeli wenu ukuthi kuyikhona lokho kade nifundela khona manje lokuqala nesibili nesithathu niyaqinisekisa confirm Toshiba.
Court, please, Your Worship. State here's the application of the defense, Your Worship. It's safe to say that the state is still standing on the basis of objecting to same, Your Worship. My colleague had indicated, Your Worship, that it's in the basis of Section 35, Your Worship, of subsection 3 of the Constitution that provides for a free and speedy trial, Your Worship, which inter alia, Your Worship, goes with the accused person having been informed of the charge with sufficient detail to answer to it, Your Worship. Your Worship, to comment there on the basis of Section 35, Your Worship, it is the state belief, Your Worship, that the accused persons at this stage, their rights were read to them. They are well aware of the charges which are preferred by the state against them at this stage, Your Worship. Furthermore, Your Worship, I hear that my colleague, Your Worship, his basis of argument, Your Worship, it's outlined in the basis of Section 6014, Your Worship, as I believe that's the underlining factor. However, Your Worship, State would like to direct this court to the case of State versus Hugo, 1976, Volume 4, SA 536, where the court provided that the heart and soul of a charge is that to inform the accused of the case that the state wants to advance against him. That is what fairness requires. Your Worship, State is quoting this case inter alia, Worship, with Section 35.3, as per the argument of my colleague, that is what the Constitution requires, Your Worship, that they get to be afforded, Your Worship, an opportunity to have access to the contents dockets, Your Worship, which this goes as per their constitutional right in terms of Section 35.3, Your Worship. However, it is the state submissions that the state, as quoted, Your Worship, has informed the accused persons know what are the charges that are preferred against them. And furthermore, Your Worship, it is worth noting that the rights of the accused person in respect of this matter are not absolute, Your Worship. Your Worship, the defense at paragraph 7.1 indicates, Your Worship, that they request for particulars, which they use the word redacted at this point, Your Worship, which is simply meaning reduced in this point in time, Your Worship. They are looking for witness statements. They are requesting for statement of the arresting officer, evidence which links the accused person, such as confession statements or any other relevant evidence, Your Worship. Your Worship, it's safe to say that the basis of Section 60, Your Worship, 14, it covers thoroughly and it provides a strict direction, Your Worship, that for bail proceedings, for bail purposes, the defense may not have access to the court, to the police docket, Your Worship. Your Worship, at this stage, the investigation is still even at its early stages. if we provide witness statements, if we provide statements of an arresting officer, that is the state giving away the whole entire investigation. That is the state jeopardizing the whole entire investigation. It is the state submissions, Your Worship, that this, what is requested by the defense, Your Worship, it's not relevant at this stage, Your Worship, to assist them in preparing for bail, Your Worship. It's safe to note, Your Worship, that at this stage, the state is not disputing to provide these particulars. It will do so at the right time when the matter is set for plea and trial, or at any stage once the investigation is finalized. But at this stage, Your Worship, based on what the defense is requesting, further like to direct the court, Your Worship, to the case of Shabalal and others versus the Attorney General of Transvaal and another, 1995, ZACC 12, 1996, Volume 1, SA 725, where the court provided that the purpose of further particulars is to inform the accused person of the case which is to be brought against them so they can prepare their defense. At this stage, Your Worship, there is no defense that is to be prepared for, but rather, as my colleague has alluded, to Schedule 6, which simply says, Your Worship, that they rest the onus, Your Worship, not a defense, and onus to prove that there are exceptional circumstances which warrant for their release, not a defense in respect of the main case or the trial itself, Your Worship. Furthermore, Your Worship, the court indicated that in order to establish whether further particulars requested should be provided, the following test should be considered: whether the refusal will be of prejudice to the accused. Secondly, is the giving of the particulars in the interest of justice? And thirdly, is it pertinent to the point in issue? Your Worship, to commence with, it is the state submissions that at this stage, Your Worship, the refusal, as it's the state submissions and request to the court, it will not be of any prejudice to the accused persons. This overlaps, Your Worship, with the second point, that the giving of the particulars, then that will not be in the interest of justice, as, Your Worship, the whole basis and argument of the state is that the investigation will be flawed. Then if they have access to what they have requested, statements of witnesses, statements of arresting officer, Your Worship, it's safe to say that they are interlinked, all these statements. The arresting officer cannot make a statement without diverging how the arrest came about, how the offense came about, the manner the offense was committed. That, Your Worship, will come from the witness statements. So even if, Your Worship, it was the statement of the arresting officer alone which was requested, Your Worship, just trying to point a picture to the court that this will not be in the interest of justice, because that statement originates from the witness statements. The witness statements informs what the arresting officer brings before this court and the statement of the arresting officer. Furthermore, Your Worship, as indicated, point 3 says the court should be considered of, is it pertinent to the point in issue? In this regard, Your Worship, the point in issue is bail. It's not trial. As I've indicated, that state, Your Worship, is not opposing to granting of the particulars. It's just a question of time at this stage. When the matter is ready, when this case is ready to be heard in court, then the state, Your Worship, will provide the copies, Your Worship. Your Worship, the case of State versus Chao and another, 2009, Volume 1, SACR 479. At paragraph 31, it simply says that it cautions the court and provides that courts must guard against the abuse of power in terms of Section 87, where the accused aim is not to advance the proper administration of justice, but rather to obfuscate the issues. The state, Your Worship, is quoting this basis of Section 87 because Section 87 of the Criminal Procedure Act, Your Worship, it makes provision for further particulars to be provided on its own. That's, Your Worship, excluding the provision of my colleague of Section 6014. It makes provision for further particular, but at this stage, the courts are cautioned to safeguard. It is the state submission that this will not advance the proper administration of justice, Your Worship, as investigation is still ongoing. Furthermore, Your Worship, the courts are requested to assess whether adequate information has been given to the defense with regard to the following questions. Does the accused person need the information to answer to the charge? At this stage, there's no charge that the accused person needs to answer to. It is only for bail purposes. The only thing that the accused must do is to provide to the court, if possible, that they are exceptional. There's no charge that the accused person at this stage should answer to. And the second point, it's the same. Will the refusal amount to prejudice? State has already provided to this court, Your Worship, that this will not be in the best interest of justice. Your Worship, in closing, Your Worship, State humbly requests the court to take into account the provisions of Section 6014, Your Worship, which provides clearly the basis, Your Worship. It says in its reading, unless the prosecutor directs otherwise. And at this stage, Your Worship, the wording, it is very clear that the prosecutor has not directed otherwise. Furthermore, Your Worship, based on my colleagues, Your Worship, which was typed by my colleague, Section 6014, Your Worship, the last sentence, Your Worship, provides that, provided that this subsection shall not be construed as denying an accused access to any information, record, or document which he or she may be entitled to for the purposes of his or her trial. It's again self-explanatory, self-clear, for the purposes of trial, not for bail. Your Worship, in conclusion, State requests court to take into account the case of National Director of Public Prosecution versus King, 2010, Volume 2, SACR 146, at paragraph 5, where the court provided that fairness is not a one-way street conferring an unlimited right on an accused to demand the most favorable treatment. It is the submissions, Your Worship, that what the accused or the request of my defense, Your Worship, will be tantamount to requesting for the most favorable treatment, Your Worship, before this court. As indicated, the heart and soul of the state investigation is still at its early stages. Any document, Your Worship, safe to put it, Your Worship, that there are no confessions. Perhaps my colleague, Your Worship, was not aware. There are no confessions which were done by any of the accused persons. Your Worship, the accused persons, they tendered warning statements just like any other Your Worship, accused persons. That's what was tendered. And that same warning statements, your state is well aware, Your Worship, that those are statements made by the defense, but state would still advance a request, not even for that to be provided, simply because those warning statements are part and parcel of the investigation. They are the ones that were tendered voluntarily to assist the state, guiding the state, giving leeway to the state in terms of where investigation should head to. That also being provided may jeopardize the whole entire investigation. Court, please, Your Worship.
Umshushisi lapha kade vezela inkantolo lapha ukuthi na ummelweni lapha ke uvezela lapha ukuthi na ke lesicelo lesike ke kade besifake lapha ke bana basifake isicelo lapha ke bona ngomthetho sisekela lapha ke ukusigaba 35 lapha ke osho lapha ukuthi na kufanele lapha ke icala ke lenu mathwala phambi kwenkantolo ke lisheshe lapha ke liqulwe lapha ke kepha ke lapha ke futhi ke akukhulumi lapha ngokuthi kufanele lapha ke ninikezelele lapha ke imininingwane ke equkethwe ke idocket lapha ke ngoba nina-ke ummelweni laphana ugxile kakhulu lapha ngathi efunda ikakhulu laphana kumthetho sisekelo laphana kosigaba 35 laphana thina-ke wonke umuntu oboshiwe noma ongaphakathi laphana-ke ejele kufanele laphana-ke icala lakhe liqulwe ngokukhulu-ke laphana ukushesha laphana-ke yena futhi ubuya futhi wagxila laphana ngokuthi uyasho laphana umshushisi lapho thina-ke nina-ke nifundelwa laphana-ke amalungelo enu akumthetho sisekelo laphana futhi nafundelwa namacala laphana enithweswe wona laphana-ke uyasho laphana-ke ngumthetho laphana-ke lonosho ummelweni laphana osigaba 6 nosigaba 14 laphana-ke osho laphana ukuthi kufanele laphana-ke umbuso ubanikeze laphana-ke imininingwane equkethwe laphana-ke khona-ke kwi-docket laphana uyasho kwenze umzekezo laphana-ke ngokucala laphana-ke lenzekayo laphana-ke lokuthi le-state versus hugo laphana-ke lapho umuntu abathoswa khona icala laphana-ke uyasho lapho thina kufanele laphana-ke umbuso unikezeleke laphana-ke wona-ke laphana-ke ummangali laphana mhlawumbe ummelweni laphana-ke imininingwane equkethelayo uma ukuthi icala leli-ke seliyazokhulunywa ngalolo suku lolo-ke laphana-ke uyasho laphana ukuthi umthetho kuwumthetho laphana okhona kumthetho sisekelo laphana-ke uyasho laphana ukuthi na-ke ngokwe-statement enisenzile laphana-ke ku-paragraph 7 laphana paragraph 1 laphana kusho laphana ukuthi nicela laphana-ke imininingwane laphana-ke yofakazi-ke itetimende zofakazi laphana-ke nifune futhi-ke itetimende futhi-ke zebamaphoyisa lawo-ke anibophayo laphana-ke uyasho laphana ukuthi futhi-ke lapha ngakulula laphana ukuthi benikezele laphana zona-ke itetimende lezi-ke esho laphana zophoyisa lezi-ke elanibophayo ngoba lapha ziyingxenye zophenyo-ke lezo tetimende lezi futhi nanizenzile-ke itetimende laphana-ke nina-ke akukho futhi apho itetimende enazenzayo lapha ukuthi na-ke nikhona lapho nanivuma khona leli cala itetimende zanenzayo lokuthiwa kubizwa ukuthi ama-warning statement enawenzayo nalaphana-ke ukona laphana-ke kuyasho laphana-ke into ekhulunywa lapha-ke ukuthi na-ke kukhulunywa ngebheyili akukhulunywa ngecala laphana-ke ngoba bona bazokwazi ukuthi na-ke benikezelele-ke imininingwane equkethwe laphana kwi-docket uma ukuthi icala leni-ke ngalolu suku lelo-ke sefanele manje-ke likhulunywe-ke laphana-ke kepha manje ngoba nisapha ecelosini sebheyili-ke angeke lapha bekwazi lapho ukuthi benikezelele yona-ke imininingwane-ke ephelele lapha ngoba lokho kube suthi na-ke sekuphazamisa-ke lona-ke uphenyo laphana-ke ngathi besho laphana nanokuthi kobe kungenziwa futhi ubulungiswa mawuthi futhi-ke inkantolo laphana-ke yena izonivuma laphana ukuthi-ke ninikezelele-ke yona-ke le mininingwane lena iqukethwe laphana-ke ngokuthi futhi-ke banisho uyakuveza futhi nichazeliwe amacala enabekwa wona-ke nanokuthi futhi nina-ke funa uphenyo lwenu futhi-ke alikakapheli lapha futhi asho ukunqaba kwabo laphana-ke nokuthi nabenikezele laphana-ke yona-ke imininingwane equkethwe laphana kuba kwi-docket laphana angeke laphana-ke kwanilimaza ndawo lapho-ke ngenxa yokuthi phela-ke khulunywa lapha-ke ngesicelo sebheyili laphana-ke akukho okuningi okukhulunywa ngawo laphana-ke ngoba futhi nokuthi futhi uphenyo alikapheli laphana-ke uyasho futhi nokuthi nina-ke ngokomthetho lapha ngokomthetho laphana-ke futhi-ke kwezawo laphana-ke amacala laphana kosigaba 6 nosigaba 4 laphana-ke ukuveze laphana ukuthi nina-ke okwenu ukuthi nifuna imininingwane mhlawumbe ibheyili-ke siyilungisele lapha mhlawumbe sezokhulunywa icala leli uphenyo lusaqhubeka-ke laphana-ke ingakho bona benqaba ukuthi na-ke benikezeleke lapha yona-ke imininingwane laphana-ke equkethwe laphana-ke kwi-docket ngoba izophazamisa-ke uphenyo.
As for pieces, Worship, in the slides, I wish to bring the following to the Honorable Court. I do concede that cases that I've cited in paragraph 3, 4, and 5. First two makes reference to the accused can have access. Number 4, the state can be ordered. And paragraph 5, the Constitutional Court, the state may be ordered. That being the case, it demonstrates that the court still retains its judicial discretion, whether in that specific case it can be granted or not. And then, Your Worship, one aspect, my learned colleague for the state, though he addressed the court, he omitted to amplify him saying the statements will be provided just for the defense in the trial. Your Worship, in terms of State versus Matebula, it's a 2010 decision, 55. It's a case, I think, that if this matter proceeds to bail, that all parties will be making reference to. In terms of this case, Your Worship, among other things, as my colleague says, the applicants bear on us to demonstrate the existence of the exceptional circumstances. The SCA has stated that, among other things, the applicant must also demonstrate that the state case is non-existent or subject to doubt. It was on that basis, Your Worship. And Your Worship, in terms of the decision, State versus Mvula.
The applicants now say when the state says it's a statement, a warning statement, will it be fair for the applicants to say, no, it's confessions?
No.
Tell the law.
No, Your Worship, that call will not be made by the applicant, they are laymen.
No, I mean for the applicants.
But the applicant can be given an advice that even though you say you made a statement to the police, upon closer look at the statement, in the world of law, your statement is this.
And advocate, you agree with the court, the issues about the alternative relief are not pointed for the court.
Yes, for the reason that I proffered initially, that yes, these proceedings are sui generis, even the state, no adverse submissions was made against the state because one understands the law courts are as busy as any other courts in the country. One to stick to the one will at some point, yeah. So, but those submissions, I can't argue that, Your Worship, because the state has not complied with the motion proceedings rules.
Because we are not strictly on
Proceedings are sui generis. So if one accepts that, immediately one accepts that, then it becomes a problem why one would not accept it. That over and above the application, there are submissions that also have to be put in a pot within which the application is being considered.
But even so, does the advocate not agree with the court that their alternative relief is not existent in their application? If the advocate doesn't want to answer, I would not.
No.
The
answer is as I've stated. That if the state submissions cannot be ignored by virtue of the fact that the state has not complied with the motion court rules, and one considers that accepts that the submissions by the defense, both the applications and the submissions that were made, so it cannot be that that aspect be cherry picked as adversely.
Advocate, I don't think I'll get the answer today to this one, but I'll try again. Advocate, your documents do not provide the alternative relief that the advocate is arguing about. They don't have it.
I fully agree with the court, as the court proposes.
And after having said that, advocate, if the court were to rule, on what must the court rule? Must it rule on what is not there on the document because of the answer you've given earlier, that the state has the arguments, if they are accepted, then the applicants' arguments also need to be accepted.
Actually, just that I'm a bit confused.
Yes.
Whether a number of thoughts are perambulating in my mind.
Yes.
Whether one will consider the papers only and not the submissions by the defense, and then consider the submissions by the state not on paper only. Because it changes the picture of everything else.
The court will be guided by the advocate. Whether the advocate is amending to include that, then the court will move on the basis of point A and plan A and B. But if it's not amended, it's only on the argument. Does not on the application, does not the argument.
Your Worship, as an officer of the court, I'd have to request a short adjournment to take instructions from the. I'm a creature of the, as the court is the creature of the law, I'm also a creature of the instructions. If I may take the instructions from my instructing attorneys, Your Worship. I apologize for the inconvenience.
Not a problem. Just do what's in the interest of justice. That's what we want.
That's the position.
ummeli wenu laphana besecela lapho ukuthi kade laphana ithi uguqancane ufuthethe laphana ke emniningwane ke ephelele kunina laphana ngoba ke into sekuvela laphana ukuthi ke statement lesiye anikezele inkantolo lapha akuveli laphana ukuthi na ke kuvela ukuthi bafuna le statement lesiye ke enasithatha ngathi laphana ke niboshwa laphana kuyi warning statement laphana ke usecela manje ukuthi na ke ucela ukuthi inkantolo ukuthi uguqancane ukuze laphana ke akwazi ukuthi akhulumisane nani laphana ke malana ke nalezi statement ezike enazenzayo emaphoyiseni laphana enkathi ke niboshwa.
Yes, 5 minutes will suffice. It seems my instructing attorney already has the instructions.
Yes. The matter stands down.
We've been busy. 5 minutes.
Court, please, may I be excused provisionally, Your Worship?
Yes.
The instructions that I've been giving is to ask for the postponement solely to file, in terms of the Magistrate Court rules, to file the notice of amendment and then serve the state properly and the state to exercise its discretion whether it wishes to following the rules. Your Worship, the date we had in mind was the 19th of February, but we will, immediately after today, we will serve the state with the date.
Laphana ke ummelweni laphana ke usecele laphana ke inkantolo laphana ukuthi ngokomthetho laphana ke wezinkantolo laphana ke bacela ukuthi ke beshintshe laphana le statement lesi basithumele abaniyazele yona ke inkantolo laphana ke usecethe ke ngalokho icala lihlehle lesicelo lesihlehle umhla ka-19 ke kuFebruary ke bazoniyazelela ke futhi ke umbuso laphana ke ngamaphepha ke mayelana ke nokushintsha kwesicelo sabo lapha ke mayelana nesicelo lesi abazosenza laphana ukuthi nabeshintshe le statement esike abasenzele basinezela inkantolo ukuze bezokwenza lapha befake laphana uplan B lona bawushila laphana ukuthi nabacela laphana istatement ke lesike ekasenzayo laphana ngathi ke niboshwe.
No objection, Your Worship.
Cases by agreement between the parties postponed to 19 February 2020
Suman.
for
Icala liyahle akhonta man usumani icala liyahle umhla ka-19 ke February ke lapho ndira khona qhutshwa ke laphana nokulalelwa ke lesicelo lesike ke sifake ummelweni la inkantolo ke okwamanje ngicela phathi ke 19 February ke ngiyabuya ngizola inkantolo seniyehlala.